Alright, Travis Wayne Goodsell, back again. Now, you guys, if you've been watching these videos on my channel, you're aware of the case of me versus the Church of Jesus Christ of Latter-day Saints, technically the corporation of the president. It's for RICO violations, treason, war crimes, bigamy, and those are just the ones that are against me. There are many other crimes the church is committing, but it requires other people to bring up the cases against the church for it. And so you can go to the Pacer site that lists all of the cases. Case number is 219 CV 00711. It's currently with Evelyn J. Furse. And tomorrow I'll be sending this recusal, or a motion for recusal, of both Judge Furse and Judge Waddups, who's the district judge who's overseeing the case. And instead of giving you a background again, I'm going to read you the case. You could go to the website. It's made available to the public, except that they charge you in order to download, let alone see the case. And so I'm going to read it right here in this video so that you can be aware of what will be in the public domain very, very shortly. Because Judge Furse, as I've been checking all day today, is still not granting the motion for service of process. And so going in tomorrow, I will present this recusal. After I ask, has the motion for service of process been approved? And of course the clerks will say, no, still pending. Okay, I'm filing this motion for recusal. And so the reasons, I give 3 reasons. And it's from the Code of Conduct for United States Judges, effective March 12th, 2019. Reason number 1 is from Canon 1. A judge should uphold the integrity and independence of the judiciary. On October 1st, 2019, my submission was assigned to Judge Waddups. Wikipedia identifies Judge Waddups as Mormon by his attendance at Brigham Young University. Pretty much only football players and those who are from another country, even they are still Mormon also, but for the most part it's Mormon. But his attendance at Brigham Young University alone is sufficient, even if he wasn't Mormon, because it shows that he has a bias for the church. The same Wikipedia page discusses a case decided by Judge Waddups in December 2009, in which he gave the appearance of going soft, which is the word they used in Wikipedia, on white-collar crimes, by issuing probation and not prison time for Davis School District employees who pled guilty to money laundering and fraud. My case, though civil, involves accusations of white-collar crime against the corporation of the President of the Church of Jesus Christ of Latter-day Saints, both issues that Judge Waddups has the appearance of being unable to uphold the integrity and independence of the judiciary. This also works for the second one, because of what the judges did to Judge Furse in getting her terminated. Because I don't put the reason in here, as the Salt Lake Tribune covers it, but her reason for getting fired is worse than his reason for not getting fired for what he did. Reason number 2, Code of Conduct for United States Judges, Canon 1. The integrity, and I put a quote from that canon in addition, the integrity and independence of judges depend in turn on their acting without fear or favor. On 1 November 2019, the Salt Lake Tribune reported that Judge First was up for review in 2019. A panel of district judges first all approved her to be reappointed. Then a selection panel decided First should be reappointed. Then Gaddy v. COP 219 CV 00554 was assigned to Judge First on August 5th, 2019. Then the panel of district judges reversed their decision and terminated Judge First, as she became the first Utah magistrate judge to not be reappointed for a second term. On August 27, 2019, the COP filed a motion to dismiss. On August 28, 2019, David J. Jordan appeared on behalf of the COP. On August 29, 2019, notice was given to both parties as to how to motion for reassignment. Whoever this David J. Jordan was, he apparently sparked the need for reassignment. On September 6, 2019, Gaddy v. COP was reassigned to Magistrate Judge Peed. Remember him? Under Robert J. Shelby, as the just fired Judge First was removed from the case. Gaddy v. COP currently is to have a hearing on motion to dismiss by COP on February 13th, 2020. The plaintiff filed 219 CV 00711 against the COP on September 30th, 2019. This was a month later, after all the mess in August, as Judge Peed, remember his name, assigned the case to Judge Waddups. Remember, he's from the first reason, who assigned the case to Magistrate Judge First. The plaintiff notified in the filing that the case was related to Gaddy v. COP, and yet they still went through this process. And the plaintiff was not notified that Judge First had been terminated, even when Judge First held a hearing to dismiss on November 1, 2019. The case was not dismissed, as the plaintiff informed the court that the defendant has been paying the evaluator from the 2008 state case against the plaintiff. Judge First ordered the plaintiff refile within 30 days. The plaintiff refiled on November 25, 2019. To date, Judge First has not approved of motion for service of process. On December 26, 2019, the plaintiff filed a second motion for service of process with an attached letter informing the court that because of Judge First's delay, justice delayed is justice denied, if you've ever heard that quote, in ordering motion for service of process. The defendant had attempted to cover up their payments to the evaluator in the 2008 state case. Judge First still has not given order for motion for service of process. In so denying the plaintiff his motion, Judge First is showing favor to the defendant and aiding the defendant in obstruction of justice. Because when you cover up facts related to a case, that's obstruction of justice. And the judge is aiding and abetting in that. Reason 3. Code of Conduct for U.S. Judges, Canon 2. A judge should avoid impropriety and the appearance of impropriety in all activities. This is a fun one. Judge Waddups and all federal judges in Utah who are Mormon have discriminatory membership with the defendant. I use discriminatory because they're supposed to be indiscriminate, as it states in the canon. 1. As Mormon, tithing is a protectionist racket forced upon Mormons to pay in full in order to participate in the religious rituals and for advancement in religious leadership. You can't become a deacon unless you're a full tithe payer. You can't become a teacher unless you're a full tithe payer. You can't become a priest unless you're a full tithe payer. You can't become an elder unless you're a full tithe payer. You can't serve a mission unless you're a full tithe payer. You can't become a bishop, high councilman, stake president, any leadership unless you're a full tithe payer. If you're not a full tithe payer, you get to be the Boy Scout leader, and they've taken that away now. Failure to pay prevents the Mormon from the rituals which the defendant threatens Mormons with rejection from a prosperous afterlife in order to justify the punishment of ritual participation denial and denial of leadership advancement. As a full tithe-paying Mormon, participation in the temple ritual of the endowment ceremony involves an oath of loyalty with the covenant of the law of the gospel and the covenant of the law of consecration. From the text after 1991. From Law of Gospel. We are required to give unto you the law of the gospel as contained in the Holy Scriptures, to give unto you also a charge to avoid all light-mindedness, loud laughter, evil speaking of the Lord's anointed, the taking of the name of God in vain, and every other unholy and impure practice, and to cause you to receive these by covenant. From the law of consecration. You and each of you covenant and promise before God, angels, and these witnesses at this altar that you do accept the law of consecration as contained in the Doctrine and Covenants, in that you do consecrate yourselves, your time, your talents, and everything with which the Lord has blessed you, or with which he may bless you, to the Church of Jesus Christ of Latter-day Saints, for the building up of the kingdom of God on the earth, and for the establishment of Zion. This was not just a religious thing. In 1897, the United States Congress passed the Edmunds-Tucker Act, which was upheld by the Supreme Court in 1890. Congress then removed all Mormons from government office in all three branches of government in the territory. This included judges, because Mormon judges were not avoiding, and here I'm quoting the text of the Code of Conduct, impropriety and the appearance of impropriety in all activities. In consideration of the above, I motion for recusal of Judges First and Waddups and any and all future reassigned judges compromised by the defendant. Attached is Evaluator Nancy B. Cohn's website before and after November 1, 2019. The pre-website is the one with the advertisement paid for by the defendant. And I'll remember to put the pictures in the video. I warned the church the gloves are off.